Hi there, welcome to the Family First Solicitors YouTube videos that we're doing just to try and put some information out there about the family courts. The first video that we're doing is about how does the court decide how to divvy up assets. It's a question that we're often asked, and it's a question that we're often asked as family lawyers from people who are right at the beginning of the process. So the first thing to know is that the court has four powers, okay? The court has four powers. It has powers over your property, called a property adjustment order. That means like your house or other things, so technically even a company. It has powers over your pension, so it can divide up a pension, and that's called a pension sharing order. It can chop it one way or another, give some to one person, take some away from the other person. Thirdly, we can't do threes. Thirdly, it can sort out maintenance between the parties. Now, remember, maintenance can go either way. It tends to go from the breadwinner to the primary carer, which is often from a man to a woman. And that's less completely definite these days, but that's what the court can do. And lastly, the court can also, thing number four, deal with lump sums. So a court can make a lump sum order. So that's the four things that the court has the power to order. Now, the other thing to know is hanging off that in kind of agreements or recitals between the parties, and on the basis there's been these agreements, the court says, and we'll make an order about the house and the pension, the maintenance and the lump sums, are agreements or recitals about smaller things. For example, an agreement that life insurance will carry on until the pensions kick in, or an agreement that both parties will share the costs of school uniform every year in September, so long as it doesn't go over X amount of pounds. That's the kind of thing that a court tends to approve. Where does it wrap this agreement up, all of these orders up? It wraps them up into something called a consent order. A consent order is, clue is in the name, an order by consent. If you don't have consent, you'll end up getting your order at a final hearing, and a final hearing won't be a consent order because there wasn't any consent, it's just an order. Now, the big thing to think about is, well, how does a judge make an order? You know, what are they thinking about when they're divvying up all the stuff? There are 8 things. Boom. Yeah, did that right. I usually forget one of them, so let's see if I can remember them. Thing number 1, the resources and the needs of the parties, okay? This is usually the most important thing. People need what they need, and most of all, they need somewhere to live, a house to live in, and then they need to work out how we're going to make ends meet. So that's the thing, for the first thing for the court that it needs to think about. Thing number 2, earning capacity of the parties. Is everybody doing what they should be doing in order to work and to make a living, make a contribution to their household income? Thing number 3, contributions. Contributions is an argument that you often find when people are going, oh yeah, but in 1974 I put £15,000 down into the matrimonial home as a deposit. Well, that kind of argument tends not to play so very loudly in court. Courts are like, well, needs wins everything, okay? So contributions. If you're Paul McCartney, hi, Sir Paul, you will be certainly aware that contributions did play a very important part in your case with Heather Mills McCartney, because it turns out being a Beatle is a stellar contribution. But most of us are not in that boat. Contributions, we'll see, okay? Thing 4, the standard of living. In normal cases, you will not be arguing over how many butlers you need, all right? And that's why the standard of living, don't get too het up about that. It tends not to play in normal people law that much. Thing number 5, age of the parties and the length of the marriage. In shorter marriages, there's less of a feeling that people's efforts and money has all been mixed into one. In longer marriages, it's very, very difficult for anybody to successfully argue that I made all the money, so I get to walk off with it, okay? In fact, as soon as there's children, that sort of tends to muddy the waters as well. Gosh, what was I up to? Number 5, that was number 5, wasn't it? Number 6, conduct. Okay, number 6 is the get out of jail free card for me, Ursula Rice, a solicitor of many years standing, who always tries to go through this list and always fails to remember all 8 things easily. So I use conduct as a way of going, oh, what are the other ones? Conduct has to be so bad, so bad, that it would be extraordinary for the court not to take account of it. I'm talking quality axe murdering, or betting the entirety of your pension that you've just drawn down because you're 55 and 3 minutes years old, and betting it on the roulette wheel. I can't think of I can think of one case I've run that has conduct in it. I've been doing this for years, okay? So conduct is not being a bit of a swine, okay? What was that? That was 6. Number 7, disability. Disability is on the list. You or your child, that often like severe autism, you know, it means needs have changed, i.e. the child really needs their own bedroom. They cannot share a room, that kind of thing. And finally, something called the benefits lost. Need a little bell. Ding, ding, I got to all 8 of them. The benefits lost means things we don't have because now we're not married anymore. I don't get to have a go on your pension. That's usually addressed through pension sharing orders. Now, that's the zoom in list. That's the kind of criteria that judges can really see when they're looking at Form E, which I'll talk about in another video, or really going into the evidence. If you like, that's the zooming in list. There's a zooming out list, because you know what? If you're a judge, very reasonable, very reasonably, judges go, well, what I need to do is to be able to look at the big picture, like an umbrella sitting over all this detail. Let's just rise up above the fray and look at the big picture. It's very easy, isn't it, when you've been told to invent a horse, to accidentally overthink it and you've invented a camel with 3 humps. So judges don't like to do that. So there are 3 things on top of my little 8 things list that they think about. Number 1, the needs of the children under 18 will always be the first consideration, i.e. number 1 for the court. Number 2, courts want to be fair, okay? Fairness is an important big picture situation for a court. Number 3, clean break. Can a court find a clean break in this case, on the facts of this case? Those are things that courts like to do. Clean breaks are great for loads of reasons. I'll talk about those in another video. Anyway, I hope that helps. We are Family First Solicitors. My name is Ursula Rice. And as it happens, the first interview costs 60 quid with us and takes as long as it takes. If you need one, you can call or email. All the details are at the bottom there. Just find our website, click to call, click to email us. It's dead easy. And we can act for you wherever you are. Most of our appointments are by Zoom. Courts are doing an awful lot of things by Zoom these days. Thank you for listening. I hope it's been useful. Watch out for more videos. Share them and subscribe. Don't forget, if you like the sound of what I'm saying and if you think I could be useful to you in the space that you are at the moment. All right, thanks.